Good morning, ladies and gentlemen. We really appreciate you being on our OKHR and Crow and Dunlevy podcast. I guess you could call it Zoomcast, perhaps. We want to remind you, Better, Faster, Stronger State Conference is still going to happen. I know a lot of states have canceled their conferences. We have not. August 10th through the 13th, 2020, same place at the Hard Rock in Tulsa. With our presenting sponsors, Crow and Dunlevy, being there. Speaking of Crow and Dunlevy, the Crow and Dunlevy Award of Excellence has been extended to June 30th. So you can go to okhr.org and recognize and honor an individual who has an outstanding achievement in the field of human resources. So back to the topic at hand. That's my infomercial, but the topic at hand, I know a lot of our HR professionals are looking for guidance. We basically had a law that was passed, and then there was a week worth of time to create regulations around that we know are ever changing. And so I am so happy to have an outstanding partner like Crow and Dunlevy, who has been partnering with us and our 12 local chapters, representing our 1,000 local members and our over 2,800 SHRM members throughout the state to help us guide us through a time of not only social distancing, but increased learning for all of us. So Adam, to you and your team, thank you so much. I can't wait to see this finished product.
Well, thanks, Mike. Thank you to our bearded wonder from OKHR. I know that you've got to drop off and have some meetings to attend to, but I just want to say before you leave, Crow and Dunlevy and our labor employment section truly treasures the relationship that we have with OKHR and all of your constituent members. We're trying to be a resource to the business community, and thank you for partnering with us, making this possible. We can't wait for the OKHR, Bigger, Faster, Stronger to happen, and it'll be in August. I think August 10th through 13th are the new dates, and can't wait to be there as a premier sponsor. And thank you so much for this opportunity and partnering with us. We really appreciate you, Mike.
Thank you again, Adam, and all the crew at Crow and Dunlevy. We really do appreciate you each and every year, each and every time that we have a need. You guys are there for us. Thank you so much.
You betcha. All right, guys, so this is part 2 of the webinar experience. This is going to be broadcast on our YouTube channel, which is going to happen the afternoon of Friday, April 3rd. We're going to get this information out to everybody. It's the same gang as last time when we assembled to talk about the Families First Coronavirus Response Act. This is take 2, the regulations. The Department of Labor have now dropped their regulations on April Fool's Day, no less. It's given us about 48 hours to digest the 124 pages that came with it. And we are prepared today to highlight for all of you and your workforces the important new guidance that we have from the Department of Labor so we can better understand the FFCRA, what it means, and how to implement it in your workforce. I'm joined today by my colleagues, Michael Bowling to my right here on the screen, Alan Hudson to my left, my co-chair of the firm's labor and employment section, Randall Snap, bottom left, and Mary Snyder to my bottom right. And everything changed up on my screen in a bit, but hopefully those introductions still made sense. But I want to have just a couple of housekeeping measures as we jump into all of this. We are going to probably take about an hour's worth of time putting this together. However, we are either going to release this in segments that are going to be directly associated with certain topics, or we are going to send out directions telling you at what point in the video you need to go to in order to learn about those certain topics. Either way, you won't have to go through an hour's worth of information to get the specific answers that you are looking for. We will signpost it along the way, and we will address it that way so that you've got the opportunity to quickly find what you need. I realize now why my screen changed. It looks like we may have lost Alan Hudson, but we will go forward as best we can, and I think we'll have him back here very, very soon. I also want to make sure that everyone knows that what we're doing today is no substitute for specific legal advice. We are trying our very best on short notice to give valuable information to the business community and human resources professionals, partnering with OKHR to do so. However, these are still very fluid situations. You should be in contact with your own employment counsel. If that's us, great. We're open for business and ready to help. If it's your own in-house counsel or other employment counsel, I encourage you to talk to them about your specific situations, as this is not specific legal advice that's being imparted to you today. I would also tell you now's a great time to be looking at the firm website for Crowe & Dunlevy. We have a lot of COVID-19 resources. We have just put together the COVID-19 Resource Center that you can find on the front page of Crowe & Dunlevy's website, www.crowedunlevy.com. We also, if you go to our labor and employment section, we have a variety of other resources. You'll find our birthday girl today, Mary Snyder, is there with one of our weekly updates, video updates that we're doing on information related to what's happening in this week. We're going to be continuing to do those on a weekly basis. We're pushing out advisories almost on a daily basis, it feels like, and then obviously doing these webinars as well. And then the last thing I wanted to say, and this kind of goes along hand in hand with what I said about this not being a substitute for specific legal advice. Please understand that the Department of Labor regulations are guidance. They are not controlling law. They are still subject to a collateral attack, to judicial review. And we know that just yesterday, a couple of members of Congress lodged a very strong, comprehensive complaint letter identifying some concerns about the scope of healthcare provider and some other issues, including some topics that our speakers will be talking about today. They may mention that when they talk about what the guidance is and how you should react to that guidance, but just a good reminder again of what this means, and that it's not a surrogate for final and binding views on what the law will be. Okay, now let's get to what you're really here for, and that is to talk about these regulations and to talk about what they mean and the guidance that they provide. Now here's where I'm going to do a little bit of signposting. Again, we will either break each of these individual sections that I'm about to describe into separate video clips and make them available on our YouTube channel, or we will provide directions to you on where you can go in the video to get to the beginning of these particular sections. But here's what we'll be talking about today, and this will help guide you when you want to see what areas of the regulations you want to learn more about. We're going to be hearing from Michael Bowling today, who's going to be talking about the regulations and their impact on emergency sick leave under the FFCRA, and specifically guidance that has now been given by the regulations about how you define those 6 different triggering events that can lead to emergency sick leave. So that will be all for Michael to tell us about. I will take the reins to talk about employee eligibility, and I'm going to focus primarily on the healthcare provider exemption. That's been a big hot topic, and for all of you who are healthcare providers or think you could be, that'll be a section that you want to dial in for sure. I'll also be talking about the small business exemptions and how you apply for those. So those will be kind of back-to-back sections that I'm going to talk about. We'll divide them up, probably do the small business exemption in one segment, and then we'll do the healthcare provider in the next segment. That will be followed by Alan Hudson. Alan's going to talk to us about the notice requirements under the FFCRA. A lot of you have your posters up, but there's other rules that came out and guidance from the regulations and that we need to talk about. Alan will give you an update on that. We'll turn next then to Mary. Mary Snyder is going to talk about the rate of pay for these various types of leave, the calculations that need to be applied, some of the hard math that you're going to need to do, and Mary is a whiz at that and is going to make sure that we talk about what the regulations tell us there. Randall is going to talk about intermittent leave under the FFCRA and the interplay between these new paid benefit laws and other laws that we're used to within the workforce. So there will be a section devoted to that. If time allows, I will wrap things up with a small segment on your record-keeping obligations. And then we'll have time at the end, hopefully, to talk about a couple of issues that came up in our first panel that we'd like to revisit now that we have the regulations. It's a lot to cover, but we've got the right team to do it. And so we're really appreciative one more time that OKHR partnered with us and gave us this opportunity to be, again, a resource to all of you in these difficult times. I said it before in our first webinar, I'll say it again here. We only get through this together, and we're proud to be a part of that together with all of you. All right, so with that said, I'm gonna pass the baton for our first segment, and so we'll note the time for this in the directions, or we'll build this as a separate segment. But Michael, let's talk about the regulations, and specifically, what do we know now about emergency sick leave and those 6 triggering events now that the guidance has been provided by the regulations?
Thank you, Adam. The Department of Labor's regulations actually provide a number of specific clarifications regarding the reasons, and some of them will go through some of those specific ones now. First, with respect to reason number 1, which is an employee who is subject to a governmental quarantine or self-isolation order, the government has clarified that if a business is subject to closure, subject to a governmental order, then there is no work available to the employees. And because no work is available, the employee is not actually eligible for emergency paid sick leave. That's an important clarification. We had all been discussing over the last week what the impact of those governmental closure orders would be on people's eligibility for paid sick leave. And that's an important note with respect to all 6 reasons. The Department of Labor regulations clarify that if no work or telework is available to an employee, then the person does not qualify for emergency paid sick leave. And so that'll be an important thing for employers to consider as they furlough employees, whether work is actually available if the person was not eligible. So an example of that would be if a person was subject to a governmental isolation order individually, but the employer had work available for them, then qualifying reason number 1 would be applicable. If the employer would not have work available for them, then they are not eligible to use qualifying reason number 1. They also provided clarification regarding reason number 3. Reason number 3 is a person experiencing symptoms of COVID-19 and seeking a medical diagnosis. And once again, that was an important clarification in terms of what's required from a record-keeping perspective and documentation from the employee. The regulations actually state that an employee must take affirmative steps to get a medical diagnosis, and that the emergency paid sick leave covers the time period when they're making, waiting for, or attending an appointment, or then are then experiencing symptoms of COVID-19. This does create an issue for employers. Today, there are many people who are experiencing symptoms of COVID-19, but are challenged in terms of their ability to be in contact with healthcare providers or to get appointments with healthcare providers. We've heard of many employees who are told simply to isolate based upon symptoms that they describe, but with no follow-up appointment and no testing, because testing has been a challenge here in our state. So this will create a record-keeping and documentation issue for employers in terms of their ability to prove up whether an employee was taking those efforts. The IRS has given some guidance on what is necessary, and so it's important for employers to ensure that they receive directly from the employee information regarding the symptoms that they're experiencing, as well as the attempts that they have made to get health care. So that'll be an important part of the record-keeping requirements. The employers actually require that affirmative information from the employee that they at least attempted to get health care in order to meet reason number 3. The Department of Labor also provided important information regarding reason number 4 that refers to caring for an individual, and that, individual is very broad, so we all wondered what that was going to mean, who is subject to a quarantine or self-isolation order, or who's been advised to remain self-quarantined by a healthcare provider. The DOL clarified that an individual includes an employee's immediate family members, so that's broader potentially than what we might see under typical FMLA, a person who regularly resides in the employee's home, or, and this is the big one, a similar person with whom the employee has a relationship that creates an expectation that the employee would provide care. So while this is narrower than anybody on earth, it actually does leave it wide open for employees to assert that the person that they're providing care for is somebody who would expect them to provide care. And that's certainly, given the definition, it could include people who go beyond an individual's family members to people within the community that they may have a relationship with that would lead them to need to provide care. So once again, that doesn't quite narrow it enough for it to be easy to administer, but does provide some guideposts for employers to use as they seek documentation and reasoning from their employees. With respect to reason number 5, in terms of the use of emergency paid sick leave to care for a son or daughter whose school or place of care has been closed, or where the child care provider is unavailable, there were some 4 important words in the regulations, and there are no other suitable person. So while it would seem easy potentially to administer this with respect to school closures, we all know the school is either open or closed, and even potentially with child care providers, where you could get documentation from the provider or see a closing notice maybe on the internet, the regulations actually provide that this leave is only available if there is no other suitable person. That can provide an opportunity for employers to ask some real questions about people's use of this leave. With respect to Oklahoma in particular, our schools have been closed for weeks now, and presumably people have been doing something with regard to childcare for their in the meantime before April 1st. And so as employers experience potentially a flood of requests for emergency paid sick leave to care for a child who has a school closure or daycare unavailability, it would be appropriate for employers to ask, what have you been doing for childcare in the interim between school closure and daycare closure and April the 1st? And is there another suitable person who can provide childcare? Now, certainly employers will want to be judicious, but it does give the opportunity for people to ask those questions. Finally, with respect to reason number 6, that was kind of the open-ended one. The department, whether the Secretary of Labor would designate any other substantially similar conditions. At this point, the Secretary has chosen not to designate any substantially similar conditions, so there should be no leave being used pursuant to reason number 6. The Secretary did indicate that the Department of Labor could designate those at any time for the remainder of the year, but so far there are no designated reasons for number 6, and so it should not be used at this time.
Thanks, Michael. A lot of good information there, a lot of things that our employers and our clients were asking us about. One brief follow-up question for you. There's obviously now this opportunity to inquire about the kind of care that they've already been getting at home. Kind of 2 follow-up questions. One, any thoughts on what happens if there's already another parent who's at home teleworking, but maybe they say, because my telework is so time intensive, we really need 2 parents home. How will that be dealt with? And then second, we've received a lot of questions from clients about, is there a difference between caring for a 17-year-old at home versus a 17-month-old? Was there any direction or guidance on those 2 issues?
Thanks, Adam. With respect to the need potentially for there to be 2 parents at home, the statute combined with the regulations indicates that the person must be unable to work or telework due to the need to provide care. If the person's unable to do telework simply because of the needs of caring for children, then that is a suitable reason to go ahead and use emergency paid sick leave under the Act. And that's a hard thing for employers to question. if somebody asserts that in fact it's impossible for them to do telework because of the need to care for children, or impossible for their spouse to do telework and thus they need to be the one at home, employers should probably go ahead and trust that. That's particularly important. People should not make assumptions about which spouse is the one that should be working versus caring for children. I know that's a question that's come up for some of our clients in terms of who they thought might be the traditional child care provider in a home. And so we want to make sure that we're not questioning who the appropriate parent is to provide that. I think it's appropriate to ask questions about what people have done about child care in the past. But once you get past that and the person legitimately is providing a good reason for why they're going to provide the care and there's no other suitable person, then I think that ends the analysis for employers. With respect to the age of the child, the statutory definition given for child is the son or daughter under FMLA, and that's a son or daughter under the age of 18. It can also potentially include children who have a developmental or other disability that means that they continue to require the care of a parent. So there will be opportunities for people to use this even for children over the age of 18 if they have a developmental or other disability that requires ongoing care. There's no difference in the statute or the regulations between a 17-year-old and a 17-month-old. So while it may seem to an employer that it would be reasonable for a 17-year-old, for example, either to just remain at home alone or not to interfere with telework, once again, while you can ask the question, in the end, I would recommend that you trust the employee's judgment upon what care their children need. And if they don't have other suitable individuals to provide that care, that they go ahead and be able to use emergency paid sick leave.
Very good. Thank you, Michael. And that probably raises another issue I should have mentioned at the outset. And that is a lot of this feels a little bit like drinking from a fire hydrant, right? In terms of the information overload. And I know we've kind of jumped into some of these issues, and some of you watching this might think, well, wait, what are those requirements that, those 6 requirements that we're even talking about? Remember, this is the second of our panel discussions that we've done. Available on the website is our first breakdown of the Families First Coronavirus Response Act, which really gets into the nuts and bolts of all the types of emergency leave that's available and what those requirements are. So if you're watching this one first, I suggest you go back and watch the first one and then get to this one so you'll have a better idea of the flow of things. And I should have mentioned too, with all the social distancing, no one was close enough to me to kick me and remind me that I probably never introduced myself at the beginning. For those who don't know me, I'm Adam Childers and co-chair of the Labor and Employment Group with Randall Snapp here at Crowe & Dunlevy. So for purposes of the segmented video or the signposting that we'll do, we're now moving into a new section, and that's one that I'm going to take on, and that is the question of employee eligibility, and specifically, I'm first going to, even before that, let me take that back. I'm going to talk about employers and how you count your employees, and then I'm also going to talk about small businesses and the exemption that has been promised but not described as part of the FFCRA. Let's turn first to this issue of guidance given to us by the regulations as it relates to how we count our employees. So first things first, the issue of the 500 employees remains the same. Those who have more than 500 employees are not covered employers for purposes of the FFCRA. If you are a governmental employer of any size or an employer with under 500 employees, you are a covered employer. Nothing about that changed. There was, however, some guidance provided by the regulations about how you do the calculations on the number of employees you have. For instance, it is now spelled out in detail that tabulation must include temporary employees as well as day laborers, regardless of which payroll that employee appeared on. I know that there's been some mental gymnastics going on as people try to decide, are they or aren't they, at or below that line, and some of that is centered on how do you treat temporary employees, and the regulations speak directly to that. The regulations also talk about What do you do if you have separate, distinct legal entities? The regulations make clear that you will count all employees across all entities if those businesses are joint employers. And that's going to be a standard that we apply under the Fair Labor Standards Act. There's a lot of interplay between the FMLA, the FLSA, and the FFCRA. It sounds like a terrible alphabet soup, but it is important that you understand and keep track of those standards when you're talking about how to count your employees. This is a place where we're seeing kind of an interesting dynamic. There are employers who previously very much resisted any notion of being a joint employer, and for good reason. It carries with it risks as it relates to liability standards and punitive damages caps and a lot of important things in the law. But this is the odd circumstance where it's helpful to be over 500 employees. Don't lose sight that how you calculate your employees could have long-term ramifications on how you're judged when you make that same argument later, that you're not a joint employer for purposes of other laws and lawsuits and claims that are made. So I urge some caution, but I would suggest to you that particularly if you're right at that level of 500 employees, or if you have questions about whether or not you're a joint enterprise, it is high time that you have that discussion with your employment counsel and use the guidance provided by these regulations to help make that determination. There is no bright line test in these regulations. They do a good job of reminding us, I think, what we knew as employment law practitioners going into this, which is that we have schematics within the framework of the FLSA to make some of these determinations. And you need to be thinking about those things if you're right at that line when it comes to the 500 employees. Now, I want to focus next on the next component. This is still part of the same segment for purposes of tracking this, but that is small businesses. We take care of very large Fortune 50 companies all the way down to small mom and pop companies. And we enjoy our relationships with all sizes of clientele. I will tell you that the ones that I've been hearing from most with the greatest concerns have been our clients that have less than 50 employees. Remember that the FFCRA said there would be an exemption available for small businesses, but it did not say it immediately applied, and it did not give any guidance on how you could even go about achieving that exemption. So the DOL regulations have been something we've been closely watching to see whether or not that guidance is provided. And I'm happy to report that we do have a much better idea now of how that small business exemption is going to work. First, if you are a small business, you're not automatically exempted. However, you can be, and the standard remains the same, which is if the imposition of these leave requirements would jeopardize your ability as a business to be a going concern. However, we now have better guidance on what that means. First, an authorized officer of the business must make one of the following three determinations. An authorized officer is not fully defined in the regulations. I would take that to mean someone within your C-suite, someone with the ability to bind the organization in terms of decisions, the people that can write contracts, the ones that can make decisions on behalf of the company. But an authorized officer is going to have to be able to meet one of three requirements. First, the requested leave would result in the business expenses and financial obligations exceeding your business revenues, and the business would cease operating at a minimal capacity. All right, so that's one of the three ways that you can prove that the exemption should apply as a small business. That is fairly restrictive. You are going to have to really put pen to paper and show that your expenses are outweighing the revenue coming in the door, and that essentially it would shutter your operations if you had to comply with these leave obligations. However, there's still 2 more sections to go. Number 2, that the absence of the employee requesting the leave would entail a substantial risk to the financial health or operational capacity or capabilities of the business because of his or her specialized skill, knowledge of the business or their responsibilities. So now we're keying in on, is the person asking for leave crucial to what you do? Are you going to be able to make the things that you make, operate the business that you have, if that individual or individuals are granted that leave? So that's the second component. The third is, I think, one that's going to come up quite a bit, and that is, can an authorized officer of your business establish that there are not sufficient workers who are able, willing, and qualified, and who will be available at the time and place needed to perform the labor or services provided by the employer or the employees requesting leave, and these labor or services are needed for the small business to operate at a minimal capacity. This really gets to the issue of what happens when you have such a density of employees who are needing this leave that it really takes away your ability to operate the business as a going concern. So those are those 3 categories that must be arrived at by an authorized individual of your small business. What else do we know, though, about how this is going to work? Well, there is no application. A lot of people have been wondering, well, where's the paperwork? What do I fill out? Who do I send it to? And how soon do I hear back? There is nothing that you send in to the Department of Labor. This is something you're going to have to establish, and you're going to have to document, and you're going to have to keep. To the extent we don't get to record-keeping obligations this webinar, you're going to have to keep it for at least 4 years. You could be audited on this. You might have to prove that you did the right thing. And so don't just say to yourself, I'm a small business, I'm exempt, and send out the memo to the employees that they're exempt. You need to do this with thoughtfulness, consideration. You need to document it, and you need to make sure that you're following those regulations that have been established by the Department of Labor. You still are required to keep that poster up in your workforce. Your employees need to be aware of their rights. That does not change, but it wouldn't be a bad idea if you're in the process of establishing one of those 3 buckets of exemptions apply to you as a small business. If you're taking that position, you certainly would probably be well off to get together with your employment counsel and fashion some sort of memorandum or other notice to your employees so there's not confusion. I see already a lot of large employers over 500 getting requests for paid leave, and now I think we'll see a lot for under 50, and they won't necessarily know. They'll have heard media reports and have a vague understanding that these paid leave benefits are out there. Our recommendation is get ahead of that and message it well, and message it in a way that tracks what the regulations tell us. So I think this is good news for the small business community, and I hope that you are taking advantage of it where it's applicable, because this could have a dramatic impact on your ability to keep your business going and come out on the other side of this pandemic with hopefully your business and your employees intact. So obviously an important area for small businesses to be concentrating on. All right, so that will end that segment of our presentation, and we'll move into the next, which I signposted at the beginning. And next also falls to me to talk about, and that is going to be employee eligibility issues. So let's start first with a couple of our bedrock rules that we know about the FFCRA as it relates to employee eligibility. Despite the fact that this is essentially, in many ways, born out of the FMLA, and we're all familiar with the FMLA's requirements of an employee having to work 1,250 hours over a calendar year, and those kinds of requirements for an eligible employee. That is not the case when it comes to emergency FMLA leave and emergency sick leave. We know that for the FFCRA, when it comes to emergency FMLA leave, you only need to be employed for at least 30 days in order to receive those benefits. That's what we knew from the FFCRA. We now know a little bit more about how that rule applies as it pertains to the guidance created by the Department of Labor regulations. The regulations spell out that an employee is considered to have worked 30 days if, one, the employer had that employee on its payroll for the 30 calendar days immediately prior to the day that their leave would begin, or two, the employee was laid off or otherwise terminated by the employer on or after March 1st, 2020, and then rehired or otherwise reemployed before December 31st, 2020. So be careful about those 30-day calculations when you've got somebody that was laid off and you bring back, or maybe you furloughed or have otherwise separated with, but you bring back to your payroll. That could have an impact on whether or not they're now eligible for emergency FMLA leave. Also, remember that when it comes to emergency sick leave, the requirement there continues to be that as long as they're employed at the moment that the need for emergency sick leave happens and that request is made, there is no 30-day requirement. If they're employed that day, then they're your employee and eligible for those emergency sick leave benefits. So better guidance from the DOL regulations than we had previously. If anything, I think it probably makes those requirements maybe a little bit even more restrictive and potentially onerous, so be aware of them when you're making determinations about who can even receive emergency family medical leave and emergency sick leave. All right, now I want to turn to what I think has been something that every single one of our healthcare provider clients and friends and the business community have been keeping a keen eye on, and that is who is a healthcare provider and who is an emergency responder for purposes of the healthcare provider and first responder exemption under the FFCRA. Remember that much like small businesses can be exempted, the FFCRA originally said if you are a healthcare provider or first responder, that individual may be exempted from the leave requirements. That's something was really important because that didn't speak to what do you do with other members of, say, a hospital staff who are in accounting, human resources, information technology. They're not necessarily direct healthcare providers. Were they covered or were they not? There was various schools of thought out there, a lot of argument amongst people that are on the side of business trying to give good counsel and advice. But I think now, at least if the Department of Labor regulations hold up, and they're already under scrutiny and attack from members of Congress, and we'll see if lawsuits in the future ensue. But this is the guidance that we've been given by the DOL regulations. And I can say pretty much unequivocally, this is as broad a scope as healthcare providers who want to be exempted from the law could have hoped for in terms of how it is defined. The regulations state that a healthcare provider is, quote, anyone employed at any doctor's office, hospital, healthcare center, clinic, post-secondary educational institution offering healthcare instruction, medical school, local health department or agency, nursing facility, retirement facility, nursing home, home health care provider, any facility that performs laboratory or medical testing, a pharmacy, or any similar institution, employer or entity, and that this includes any permanent or temporary institution, facility, location, or site where medical services are provided that are similar to such institutions. This is broad, everybody. It is intended to be that way. And remember that the public policy decision is we need people that are out in the field working on this emergency pandemic crisis, and providing those kinds of leave benefits puts an economic stress on those healthcare providers and takes away from first line responders. So the DOL responded, and that the scope seems to indicate that public policy. the statute or the regulations also say this exemption extends to those who contract with those who provide those sorts of services. So there are even tentacles of this that extend to those who contract with what's defined as a healthcare provider. As it relates to emergency responders, again, those are defined broadly to include, quote, anyone necessary for the provision of transport, care, healthcare, comfort, and nutrition of such patients or others needed for the response to COVID-19, which includes, but it's not limited to, military, National Guard, law enforcement, correctional institution personnel, firefighters, emergency medical services, physicians, nurses, public health personnel, emergency medical techs, paramedics, emergency management personnel, 911 operators, 911 operators, child welfare workers, and service providers, as well as public works personnel and persons with skills or training in operating specialized equipment or other skills necessary to provide aid in a declared emergency. Okay, look, not a big fan of having to read large quotes of passages of regulations, but this is important if you're in the healthcare field. You need to look at those regulations, you need to consult with your employment counsel, and you need to talk about the risks that some of this may be attacked later on. But from our point of view, it appears that most healthcare providers are going to be able to say categorically they are exempt from these leave benefits, with probably just a few exceptions, and those you know, are probably worth a whole other webinar for those of you that applies to. But if you're a healthcare provider and you haven't made your final decision on this, you need to be thinking about this. Now, some of you may be thinking about providing it anyway. Provide those benefits to those who aren't on the front line. You can still make a case-by-case decision, but you've got to be very clear about that when you're making that known to your employees. You need a good policy in place. We do believe that that will give you the opportunity to get the tax credit, even if you're an exempted employer, but you choose to give some of those rights, but you want to be extremely careful about how you message that and how you provide that to your employees. There is case law under the FMLA that you can provide rights under the FMLA, even if you aren't required to. So you need to make a reasoned and well-educated decision about that before you go into those waters. Okay, that ends the segment, the two segments that I have provided, the last being a focus on employee eligibility and specifically some discussion about healthcare provider definition. So I'm gonna turn now to Alan Hudson, and we'll mark this on our time stamp. This is when we're gonna talk about the notice rights and what the regulations tell us about those. Alan, take it away.
Thank you, Adam. Yeah, let's real quick talk about notice. And we're going to break this down into two categories. The first being the notice that the employer is required to give to its employees. And the second will be the notice that an employee is required to give his or her employer if they need leave under the FFCRA. Before I jump into this, I would caution employers in being overly punitive with employees that are having difficulties getting them the notice that the employer feels like they need. Again, we're in weird times where it's hard to get into a healthcare provider and get some of the information that the employer quite frankly needs for the tax credits on down the road. But really try to work with your employees, because again, to the extent you're over punitive with them, I'm afraid that you may be hearing from that employee on down the road, and we certainly want to avoid those situations. From the employer perspective, it's pretty easy, guys. The DOL has provided a model notice for employers to use. Anybody that's covered by the FFCRA should have that notice, and if they don't, they need to go to the Department of Labor's website or reach out to counsel, get a copy of it to make sure that gets posted. And before I talk about where or how to deliver the notice, I do want to point out, even if you believe that you are exempt from the FFCRA or that certain employees within your workplace are exempt under either the healthcare provider exemption or the small business exemption, you still need to post the notice that the DOL has issued. I think, again, that you were just asking for problems if you don't do so. As far as how you communicate the employee's rights under these laws, the employer can post the notice in a conspicuous place on the employer's premises. Generally speaking, this would be wherever your notices for other state and federal laws are posted, whether that be in a break room or, again, some other common area in which employees have access to it. You can also email the notice to employees. That works for some employers. It doesn't for others. You can send the notice by direct mail to employees. Obviously, I think there's some risk involved in that to the extent you don't send it certified mail, because it could be easy for an employee to either say they didn't get it or it get lost in the mail, which does happen. And finally, the employer can post the notice on the company's intranet. Again, that works great for some employers, and some employers don't have that type of technology. Again, I mentioned that the DOL has issued a model notice. My advice would be that you use the model notice. In doing so, I think you eliminate any argument that you didn't meet all of the requirements that the DOL wants you to meet with respect to the notice. However, you can take those notice requirements and create your own notice if you so choose. The notice needs to be posted from April 1, 2020 until December 31st, 2020. So, in a few months, if everything, knock on wood, settles down and we are getting back to normal and the need for this type of leave seems to have decreased, that doesn't mean, go into the break room and rip the poster down. It needs to remain up in a conspicuous place for employee access until, again, the end of December 2020. Now, let's switch gears, and I think most of the folks that are going to watch this are more interested in the notice that an employee has to provide them. And I'll start by saying an employer is permitted to implement reasonable notice procedures that an employee needs to follow. And generally speaking, the types of notice procedures that an employer already has in place with respect to FMLA leave or any other type of leave are likely to be sufficient. However, again, to the extent an employee is having a difficult time meeting those existing policies, an employer should be nimble enough to try to work with that employee in getting the information that the employer needs. The employee also has an obligation to notify the employer as soon as practical with respect to their need for leave. So again, if they realize they're going to need childcare due to a school closing, almost as soon as they realize that or shortly thereafter, they need to be providing notice to the employer that leave is necessary. Also, we get into issues where you've got an employee, they don't personally reach out to you, but they have their husband or their mom or some other relative contact you and alert you to the fact that they need this leave. Again, in most situations, that's going to be sufficient. So just because the employee doesn't contact you personally, again, don't take a hardline stance in requiring notice from the specific employee. So generally speaking, we're going to get into a little bit of detail, but if an employee needs leave under either the paid sick leave or the expanded FMLA leave, they need to give you at least 4 categories of information prior to taking the leave. The first being the employee's name, the dates for which the leave is requested, the qualifying reason for leave, and oral or written statement that the employee is unable to work due to the qualifying reason. And if you can get this information in writing, great, but they can also provide it to you orally. And then on your end, you need to be obviously making notes of this information, keeping track of this information, and that gets a little bit into the record keeping that we may get to at the end of the presentation with respect to how you're going to get these tax credits on the back end. So again, orally providing the information is sufficient if it can't be done in writing. With respect to paid sick leave, the employer can request and should request additional information. And I think Michael went over the 6 categories kind of broadly with respect to how the regulations have addressed them. But if the employee is subject to a federal, state, or local quarantine or isolation order, the employee also needs to provide the employer the name of the government entity that issued the quarantine or isolation order. If the employee has been advised by a healthcare provider to self-quarantine, or if the employee is suffering symptoms of COVID-19, the employer can also require the employee to provide the name of the healthcare provider that directed them to self-quarantine and or that is treating them with respect to these COVID-19 related symptoms. If the employee is caring for an individual that is subject to a government isolation order or who has been told by a healthcare provider to self-quarantine, the employer can also then ask the employee to provide the name of the government entity that issued the order and or the name of the healthcare provider that told the relative or whoever they're caring for to self-quarantine. Again, these are going to be a little bit tricky because I suspect that a lot of the answers you're going to get from employees are, look, I can't get into my healthcare provider because they've told us to stay as far away from their building as possible. And so again, you do need to work with the employee. You could see if the employee could get in contact with the healthcare provider via phone, if they could fax some sort of statement to the employer. I think there are ways around this, but again, try to work with your employees to get the information that you're going to need on the back end to get these tax credits. If the paid sick leave or expanded FMLA leave is needed due to a school closure or daycare closure, the information that the employer can require the employee to provide consists of the name of the child being cared for. I think that's probably fairly obvious. The name of the school, place of care, or child care provider that has closed, and a representation from the employee that no other suitable person will be caring for the child during the period in which the leave is necessary. So again, that's the type of information that you can request from an employee when they need the leave to care for a child due to a school or daycare closing. And finally, with respect to the tax credit issue, I'm not going to dive into that, quite frankly. I don't have the expertise to get into tax-related issues. However, if you need further information from the employee to get the tax credit, then you can request that information from the employee. And in fact, if they don't provide the information, that would be a basis to not provide the leave to the employee.
Very good. I appreciate that. To our mountain man, Alan Hudson, he's got the beginnings of his pandemic beard there. It's looking good on you though, Alan.
I've been inspired by Mike Shaw.
Yeah, exactly. We could all aspire to have that shaggy of a beard. And Alan, I would just mention, after hearing your part of that presentation, that obviously something employers are going to be wanting to do is get these kinds of documents together for providing that notice and documenting it. You might mention some of the work that we're doing in that area. Obviously, others may have other resources, but what kind of work have we been doing on that issue?
Certainly, we've been working on internally creating forms for our clients to use to either follow along with and ask the right questions and fill in the information, or to provide to the employee directly to provide, again, the information that you're going to need from the employee prior to them taking the leave, and also the information that you're going to need, most importantly, on the back end to get these tax credits.
Absolutely. So that's obviously a resource that we have, and I'd like for everyone to know about. And obviously, we've been putting together FFCRA policies, basically anything that touches on this and that you need documentation with. That's something that we have been addressing with clients. So that closes out that portion that Alan was talking about. So we'll turn to our next segment, which will be commandeered by our birthday girl, Mary Snyder. But before you jump into your topic, which is going to be talking about the calculations and rates of pay for these various paid leave benefits, I'd be remiss, and I'm sure we're going to get questions from audience members if we didn't get the name of that feline that made its appearance on your screen a few minutes ago.
That was Pete. I was trying to keep him from coming and laying on the computer keyboard, which is his favorite place to lay.
Well, we're sorry to have interrupted his preferred place of slumber, but that goes with social distancing, everyone. We're doing our best wherever that finds us. But Mary, why don't you jump into our next topic and talk about those rates of pay and what the DOL regulations tell us.
Sure. So we now have some better information about exactly how you need to go about calculating both how much leave entitlement folks are entitled to and how you calculate their pay. So let's start with paid sick leave. We all, I think, at this point have ingrained in our head 80 hours. And yes, that is true for people who are full-time. And for definition purposes under this law, full-time is 40 hours. So over the past few years, lots of employers have started to think of 30 hours as full-time because of the Affordable Care Act. But this is different. This is 40 hours is full-time. Or if somebody does not have a regular schedule, but over the past 6 months, they have worked an average of 40 hours per week, then they are entitled to 80 hours of this paid sick leave. Now, if you are calculating someone with an irregular schedule to try to figure out whether they meet that 40 hours on average, it's important to note that the regulations clarify that we actually need to also count paid time off that they have taken. So if they are, out on some other kind of leave, you have to count that as hours worked for determining whether they averaged 40 hours. Part-time employees are not entitled to 80 hours. So you need to be looking at, okay, first, do they have a normal schedule? If they have a normal schedule, what would they have worked over the course of 2 weeks? That's how many hours they're entitled to. But for those who do not have a normal schedule, you need to do an average. And interestingly, the way the Department of Labor defined it in the regulations, we have to look at the average over calendar days. So we are not averaging the number of hours worked on the days they worked. We're looking at the total calendar days. If they've worked for more than 6 months, we're supposed to look at the average number of hours worked, including hours for which they received paid leave, each calendar day. We're going to get an average, and then we're going to multiply that by 14. And that's how you get how many hours they're entitled to. Now, if they've worked less than 6 months, the government says, well, let's look first to see, did you have an agreement with this person on how much they would work on average per calendar day? This is confusing to me because who makes an agreement on how much on average people work per calendar day? They make agreements maybe how much they work per work day, but maybe this is the idea that, well, we agreed you would work 5 hours per day during the weekdays and none on the weekends or something like that. If you have an agreement, look at what your agreement was, and if it's pretty certain, then you provide leave for 2 weeks under that agreement. I think most employers with part-time employees, those employees often have schedules that vary. So for those folks, we're gonna again average the number of hours worked per calendar day over the full period for which they're employed. And again, we have to count hours for which they received paid leave. And then once we get that average, again, we're gonna multiply by 14. So for paid sick leave, the regulations give us these calculations. And that's what we're going to go with. This is going to be a pretty heavy calculation, intense thing for payroll folks. If you have a lot of people on these leaves, it's going to be time consuming because there are a lot of calculations to do. Once you know how many hours they're going to get if they're part-time, you also have to figure out what is the rate at which you need to pay them. Well, for the sick leave, if they are for one of the qualifying reasons number 1 through 3, and if you don't know what those are, take a look at the Q&As from the DOL or the statute itself, and we have links to advisories where we explained what these reasons are. So for reasons 1 through 3, which relate to the employee's own health, the employee is going to get paid the greater of their average regular rate of pay, and we're going to talk about what that definition is in a bit, or minimum wage, whether that's federal or state, whatever the highest minimum wage that would be applicable to them is, but up to a maximum of $511 per day and $5,110 total. That's the same as what we've been hearing from the very beginning. For qualifying reasons 4 through 6, it's again what we've been hearing from the beginning, which is 2/3 of that amount just described. So again, we have to look at the regular rate of pay, up to $200 per day and a total of $2,000. Now, it's important to note that the regulations do say that these amounts may be calculated in full day or hourly increments for those reasons 4 through 6. So when we go on to talk about intermittent leave, this will come into play, but where someone is using only a couple of hours of this time in a day, you can calculate this on an hourly basis. So let's move on to the expanded family and medical leave. The way that the Department of Labor has defined this, they say, well, an employee gets 12 weeks of this expanded family and medical leave, but that is decreased by any FMLA time already taken in the employer's FMLA year. So you may measure it on the calendar year, or you may do it on a rolling basis going backward, whatever year you use. If an employee's already used some FMLA, that's going to decrease the expanded family and medical leave to which they're entitled. But otherwise they get 12 weeks, up to 12 weeks. However, those first 2 weeks are not paid under expanded family and medical leave. They may be paid under the sick leave we just talked about, but the idea is that under the expanded family and medical leave, those first 2 weeks are not paid. Now they might run concurrently with the paid sick leave, or they might run concurrently with your own leave policies to get that 2 weeks paid, but you don't pay it under the actual law itself. After 2 weeks, an employee is entitled to 2/3 of their average regular rate, again, we'll talk about that in a second, multiplied by the employee's scheduled number of hours for each day of leave given. Again, this is capped out at $200 per day for up to 10 weeks of paid leave. So a total of $10,000 for this form of paid leave. For employees who have a normal schedule, again, this is easy, right? You just look at what their normal schedule is and they get up to 10 weeks of paid leave for this. But again, if their schedule varies, we have to do some calculations, and unfortunately, they're not the same. They don't even use the same factors going into them. So you have to look at different factors. So if you cannot determine the number of hours the employee would have worked on the day that they are asking for leave, well, let's take a step back. Let's say the person, you would know, okay, but it's a Thursday that they need leave, and on Thursdays they always worked 8 hours. Or we know they would have worked 8 hours during this period of time because of some reason within your business. Well, then you just pay that amount. But if you don't know how much they would have worked because the schedule varies on an ongoing basis, you again have to look at averages. If the employee has worked for more than 6 months, this time we're going to average the number of hours the employee was scheduled to work, and again, including hours where they ended up taking leave. We're looking at what were they scheduled to work, not what they did work. On each work day over the 6-month period that ends on the day they first want to take leave. So you look at the day they want to start taking leave on Monday. You're going to go back 6 months from there and say, what was their schedule? I anticipate this may be challenging for employers because employers don't always keep the schedules going back, and that's not part of record keeping that you're required to keep under the FLSA. So this may pose a challenge, but that's what the regulations are telling us we're supposed to do. And then you pay out leave based on that average number of scheduled hours. If the employee worked for less than 6 months, we again look at, did you guys agree to something? Did you have some agreement at what the schedule would be? If you do, that's what you pay out for the 10 weeks of the expanded family and medical leave. But if you don't have that agreement, then you're going to do that same averaging just over the period of time the employee has been employed. So if they're less than 6 months, however long they've been employed, you're going to look back over that period of time. This leave, again, can be calculated in full day or hourly increments. If it's calculated in hourly increments, the DOL suggests that you pay the employee 2/3 of the eligible employee's average regular rate, and again, we're going to talk about that in a second, for every hour that the employee takes leave. So if they take 2 hours of this leave, you're going to pay them 2/3 of their pay for those 2 hours. Anybody who's been following our seminars and advisories over the course of years knows that I talk about regular rate of pay all the time. And this is actually close to the same calculation. The DOL has said for the regular rate of pay, when you're trying to figure out what you pay somebody who is taking one of these FFCRA paid leaves, either if it's paid sick leave or the expanded family and medical leave, we're going to first look to the FLSA's definitions of the regular rate. You've got to calculate everything in that you would calculate into the regular rate under the normal FLSA overtime provisions. So non-discretionary bonuses, pay, shift differentials, things like that. And there's a whole set of regulations with a lot of guidance as to what goes into the regular rate. We've got to take that, and the way the regulations define it, I had to reach out to one of our corporate attorneys and say, can you help me make sure this math is right? The way they say one should calculate it is that you should look back over the period of 6 months going backward, or if they've been employed less time, the full period of employment, from the time the employee first takes leave, and get an average of the weekly regular rates weighted by the number of hours worked for each work week. If you follow that, it's a very long and complicated set of averaging a bunch of different factors. But in the Q&A, after the regulations came out, the DOL Q&A changed on question, I think, I can't remember what number now, and one of their questions where they talk about the regular rate. And they said, okay, the employer can do this calculation pretty easily by computing, adding up all of the compensation that would be part of the regular rate of pay over the applicable period, which is 6 months or whatever period they've been employed, if that's less than 6 months, and divide that by the sum of all hours actually worked in the same period. I reached out to our numbers folks to say, do you always get to the same number by doing these? In my head, my calculations I've tried, you always get to the same. They said, yes, that's just the simplified, easy way of doing this calculation. So for regular rate of pay, we're going to add up all of the compensation that goes into regular rate calculations, and then we're going to divide it by all the hours worked during that same period, and that's the hourly rate that you're going to have to pay out. Now you might be asking, well, what do we do for exempt employees? There is no discussion in here as to how you calculate the regular rate for exempt employees. I believe that the intention would be that they're just going to get their salary. However, there is a provision in the regulations that say, hey, an exempt employee who takes either of these paid leaves, that does not impact their exempt status. So I think there's still an open question. I think you probably can pay out exempt employees on less than a work week basis, but there's an open question there. And I'm sure hoping that whether through additional regulations or Q&As from the DOL, we get some more guidance on that, because this is complicated and challenging in regard to our exempt folks.
Thanks, Mary. You know, I often refer to Mary as our wage and hour guru, but I don't know that we've had a finer showcase of why that is the case than this morning's discussion. It is a challenging area, as Mary said, and I'd remind our audience that you can also, we'll have a client advisory that will be going out on all of these issues, and so look for that and look, as Mary said, for further guidance that we may receive from the DOL, because not all the answers are there, but we certainly are further along than we were when the FFCRA first got passed into law. Okay, so that'll finish up that segment. We'll turn now to Randall. Randall, when he is not busy explaining to everyone that the Kansas Jayhawks did, in fact, win the NCAA basketball championship this year, regardless of the lack of postseason. Although I'm sure Michael, our resident Duke fan, might say there was still a chance for the Blue Devils. But nonetheless, when he's not pontificating on that issue, he's been very busy with all of our clients in the business community on the FFCRA as well. And we've asked him to talk about intermittent FFCRA leave, as well as the interplay between the FFCRA and some of our more traditional employment law structures that are out there. So Rock Chalk, Randall, tell us what we need to know about that area of the regulations.
And thank you, Adam. We've been getting a lot of questions about intermittent leave, and one of the reasons I think that we've been getting those questions is because intermittent leave guidance is pretty much going to be a function of the regulations rather than the statute, and the statute didn't speak it to it very much. So everybody's asking, you know, can you get intermittent leave under the FFCRA, similar to what you could do under the FMLA? And the answer to the question, at least as for now, is that you can get intermittent leave under both the Paid Sick Leave Act and under the Emergency Family Medical Leave Act. However, you can only get it under certain conditions, and the regulations state that you can only have intermittent leave if both the employer and the employee agree to it. Now, that may be an area that could be subject to change, because one of the issues that the congressional letter raised to the DOL was the requirements that are in some of the Q&As that said that the employer had to agree to intermittent leave in order for an employee to be eligible for it. So there's some pressure already being placed on the DOL to remove the requirement that the employer has to agree to allow intermittent leave before intermittent leave can be allowed. So stay tuned for that one. We'll follow up with that as things go on. The condition under which intermittent leave can be allowed is the condition for childcare. In other words, if the employee needs to be off work because of the closure of a school or a daycare center or the unavailability of childcare. And that is really the purpose of the Emergency Family Medical Leave, but is also one of the qualifying conditions under the Paid Sick Leave Act. So, for example, if an employer has an employee working in the office still, they're still coming to work, they can work part of the day but need to go home at some point because their childcare needs, their childcare provider has to leave at a certain point, and they work, say, 5 hours but need to go home for 3 hours, then you can have intermittent leave to cover that 3-hour period. So it is available under both the Emergency Sick Leave Act, but only in the child care qualifying reason. If the need for the emergency sick leave is for any of the other 5 qualifying reasons, then intermittent leave is not allowed. It is allowed, obviously, for the EFMLA, and even if the worker is teleworking, it's allowed under the EFMLA. What basically needs to happen is the employer and the employee need to agree upon what the increments are that they're supposed to record for the use of the intermittent leave. So it is available. It is available under certain circumstances, but really keep in mind that under the Emergency Paid Sick Leave Act, it would not be available unless it is for the child care qualifying reason. Now, there may be some situations where, for example, a person has been under a quarantine order for several weeks prior to April 1st when the FFCRA goes into effect, and at some point they're released by their doctor to return to work after only taking 1 week of the paid sick leave. In that situation, they would only be required to use the half of the paid sick leave, or 1 week's worth, 40 hours. They'd still have the other 40 hours available. That's not really intermittent leave, but there are situations, even under the other qualifying conditions, in which an employee would not be required to take the entire amount of the leave in one full block. And again, for intermittent leave, similar to what's under the FMLA, the traditional FMLA, you can only count as intermittent leave the actual hours that are used. So under our example, if the employee went home after 3 hours, after 5 hours and took 3 hours of sick leave, you would only dock their 80-hour allotment for the 3 hours taken on each day. If it's for FMLA purposes, say for the entire week, they work 5 hours every day, go home for leave for 3 hours every day, then you would use you'd only use 37.5% of their weekly allotment under the FMLA. So only count for intermittent leave that which they're actually using. So that's basically on intermittent leave. Stay tuned, because this may change over time if the DOL feels like the pressure from Congress is sufficient to basically amend the rule on intermittent leave. So now that the regulations also have two other sections that deal with the interplay of the FFCRA with other acts. And the first one is a section that deals with the interplay between the Emergency Sick Leave Act, emergency sick leave provisions of the FFCRA, and the Emergency Family Medical Leave provisions. Mary already dealt with this in very general details, but basically you have 12 weeks of leave under the Emergency Family Medical Leave Act, and the 10 weeks, the first 2 weeks are not paid. Obviously, you can use, if you have it available to you, emergency sick leave to pay for the first 2 weeks of the 12-week allotment under the Emergency Family Medical Leave Act. There may be some situations where an employee has already used up their 80 hours, their first 2 weeks basically of the Paid Sick Leave Act. For example, they were self-quarantined for a period of time, used up all 80 hours, already were paid for that. Then down the road, sometime between now and December 31st, for whatever reason, they lose their child care provider or something like that, they need to elect to take leave under the Emergency Family Medical Leave Act. If they've already used up their paid sick leave, they cannot use it again for the first 2 weeks of the 12 weeks of the EFMLA. So that would be a situation in which the first 2 weeks are not paid. Now, what they could do is use their any kind of other leave allotment that the employer has, vacation pay, PTO, or something like that. The employer cannot require them to do that, but they can use that if they have it available to them. If the employer says, why don't you use your PTO? And they say, no, I don't want to do that, they would still retain that PTO. There may be a kind of a flip side of the situation is say an employer has used up all of their FMLA for the year. And an example would be if they spent the first 12 weeks of 2020 on FMLA leave for some other, one of the traditional qualifying reasons. And then now the FFCRA comes into effect on April 1st, and they need off for a qualifying reason under the paid sick leave, say they need child care. They can go ahead and use their 2 weeks of paid sick leave at this point, even though they've used up their FMLA. The flip side is if they've used up their paid sick leave, they can't use that to cover the first 2 weeks of FMLA. So that's what the regs say about the intersection between the Emergency Sick Leave Act and the Emergency Family Medical Leave Act. There was also a separate section of the regulations that deal with the interplay between the Emergency Family Medical Leave Act and the actual traditional FMLA, which we've had in place for years. And we need to step back and basically remember that all the Emergency Family Medical Leave Act does is provide for basically another qualifying reason why you can take FMLA. FMLA, you get 12 weeks of unpaid leave. Under the Emergency Family Medical Leave Act, you get the 12 weeks, but also the 10 weeks of those are paid, but it's the same 12 weeks. In other words, the EFMLA does not provide an additional 12 weeks to the employee for taking Family Medical Leave Act. So if the employee has used up any of their FMLA leave, that's going to count against the 12-week allotment that they have. And the other interesting juxtaposition here is that the EFMLA is only in effect for the period from April 1st to December 31st. And what the regulations say is that any FMLA leave taken for EFMLA purposes during that 7-month period is going to count against the 12-week allotment. And that's true even though the employee may have a separate 12-month period set aside for FMLA. Say they had a reason to take FMLA in July of 2019, they go on a rolling 12-month period for their 12 weeks, and that 12 weeks still covers part of the EFMLA period. They're still only going to get the 12 weeks at that period of time. So if any of the EFMLA leave is used during the 7-month period, you have to count that against the 12 weeks. Now, if the employee does not use all of their EFMLA leave, they say they take 8 weeks of EFMLA leave, they still have 4 weeks available for that, which they could use for FMLA, traditional FMLA purposes later on. So there's 12 weeks total to be allotted between the two forms of FMLA leave. One of the other interesting aspects of the regulations is it does say that unlike traditional FMLA, the EFMLA is a paid leave provision, but it only pays, as Mary said, 2/3 of a pay up to a certain limit. The regulations do provide that an employee can supplement their income by taking some of the other of the employer's paid leave allotments, say vacation pay. So an employee who's getting 2/3 of their pay by virtue of the EFMLA can still go in and say, I want to use my vacation pay for 1/3 of my pay in order to supplement their difference. That's something different in the regulations for the EFMLA that we don't have to worry about under FMLA. So they felt like it was needed to put that in the regulations.
Very good. I appreciate that, Randall. So we've gone longer already than we had originally planned, but that was by design to have a little bit of flexibility because there is just so much to cover. And as you can see, some of it is highly complex. We had a small space saved here at the tail end to talk about record keeping obligations, as well as some regulatory guidance we got on remedies that will be available for discrimination, retaliation, interference with the rights that are accorded to employees by the FFCRA. Here's what I think is a good idea to help us kind of finish things up is that particular part was actually written by Associate Melissa McDuffie within our Labor and Employment Group. It's going to be part of the advisory that we roll out. So look for that to be coming your way soon. It's a good reminder too that it's not just the folks that are up on the screen right now that played a part in putting this together. We had input from not only Melissa McDuffie, but also Evan Way and shareholder Tanya Bryant. All of their work is going to be compiled along with work that everyone you see here on the screen compiled into an advisory. This is so long, we're going to break it into segments and you're going to get an opportunity to see all that the regulations hold that is important for you to know. And that'll include that record keeping obligation that I just alluded to. The last thing I want to do before we wrap things up, and this is something that Mike Shaw asked for in particular, and he asked for it because I know a lot of you are dealing with this issue, is, and this is really unfortunate, but we're seeing a lot of people having to be laid off or hours cut, and that really implicates unemployment compensation and issues that are related to that. We've been talking at length now about the FFCRA, but that's just one of many pieces of legislation passed by Congress impacting employee rights and benefits. There's also the CARES Act, which in addition to having a lot of stimulus implications for loans that many of you may be looking at, and I should mention here as well, we're looking at those in depth with our group and others within the firm, and can obviously provide assistance there. But it also has some considerations as it relates to unemployment. And Michael, it's been a while since we've heard from you at the beginning, but let me give you a chance to talk about, can you let our audience know what are some of the changes that we've seen made at the federal and the state level impacting unemployment compensation? I think it's important for our employers to know about and be able to impart that wisdom to employees if they are in that unfortunate situation of having to let some people go.
Definitely, Adam. So there have been some major changes, and we'll give a thumbnail sketch here. Could probably do an entire hour on unemployment if we wanted to. Typically with unemployment, there's a 1 week waiting period. So the time between you lose your job and when you first become eligible for unemployment, there's typically a 1 week time period when you don't receive benefits. That 1 week time period has been waived both federally and with respect to the state of Oklahoma. So people can begin to immediately receive unemployment benefits during this time. Also, for unemployment benefits in Oklahoma, typically we have a 26-week period of eligibility. That has been extended by an additional 13 weeks by the federal government. So people will have up to 39 weeks of opportunity to take unemployment benefits. And the third major change relates to the weekly benefit amount pursuant to the coronavirus relief that's come from the federal government. The weekly benefit amount, which for 2020 was $539, has been increased by $600 a week, but that increase only lasts currently through July the 31st of this year.
Very good. And for those of you who are going through reductions in force or talking to employees who are thinking about going to unemployment rolls if they have reduced hours, I know those are questions that you're facing. And I hope that provides you with a little bit of a primer on what those changes in the law are, because I know we're all just trying to do our best to get through these times, and sometimes that's important information to pass along. Before we close, I've said thanks to members of the group here and those who are off screen that have made this possible. I want to also say a special thank you to Brooke Hannenborg and the marketing department here at Crowe & Dunlevy. And particularly Stephanie Turner, who you can't see, but is just off screen here and making sure that I don't blow anything up with my lack of technology skills. And we really are putting tremendous pressure on their department to get all this information out to all of you, and it wouldn't be possible without them doing the hard lifting and hard work that comes with it to get that message out there. So thank you to them. And finally, in closing, thank you, OKHR, once again, the State Council, for giving us this opportunity, Mike Shaw and all the volunteers that make that organization tick. He's right. There's a lot of these upcoming state get-togethers and conferences that are just being canceled left and right. And that has not happened. August 10th through 13th, we hope that the world is back the way it used to be, or at least some close facsimile thereof, and that we are all together and we get to be a part of it like we always have been for over 20 years and counting now as the principal sponsor and a big partner to the HR community. So in closing, I just hope that everybody out there is staying healthy, you're staying safe, and let's pull on this rope together and get to a place where we've done all that we can to make our workforces as safe and productive as we possibly can. So thank you, everybody, and we hope to talk to you soon, and be sure to check in for all those advisories and updates that are on our website. We really do want to help you as you get through this, all of us together. Thanks.